stand by. Good day and welcome to the Foley's Employee Benefits Broadcast Conference Call. Today's conference is being recorded, and at this time I would like to turn the conference over to Mr. Isaac Morris. Mr. Morris, please go ahead.
Thank you. Well, good day, everyone, and welcome to the Foley and Lardner Employee Benefits Broadcast Summer Edition. In today's broadcast, we will be addressing three great topics. First, I'll be talking about various aspects of healthcare reform. We'll then hear about the Supreme Court's decision in the DOMA realm. And lastly, we'll have a presentation about the U.S. Airways v. McCutcheon decision, which deals with plan subrogation. I just want to take a brief moment and introduce today's speakers. I'm going to do so slightly in a different order than were presented on the slide. First, I'll be speaking about various aspects, kind of the latest and greatest of healthcare reform. We'll then hear from Sam Hoffman, who is a partner in our San Diego office, and Sam will be speaking about the Supreme Court's DOMA decision. And then finally, Mike Woolover, who is a partner down in our Chicago office, will be speaking about the McCutcheon decision and plan subrogation. Just to get a few housekeeping items out of the way, these are the normal housekeeping items that we always cover in every presentation, but they're worth repeating here. Today's program is going to last about an hour. If we have time at the end, there'll be a short question and answer session. To the extent we don't have time to get to questions that you submit during the presentation, we'll follow up with you afterward, and you're always welcome to email the individual presenters as well, and that information will be shown at the end. If you experience any problems with Adobe Connect, please call 1-888-569-3848 for technology assistance. If you need any audio assistance, dial star, then 0 on your telephone to reach an operator. Again, we encourage you to submit questions during the program. You can type your question right into the Q&A box on the right side of the presentation slides, and then we'll respond, hopefully during the presentation at the end, and if we can't get to it then, we'll follow up with you afterward. To ensure that you get the most out of today's presentation, we encourage everyone to maximize the PowerPoint to full screen usage, and you can do that by clicking the full screen button, which is located above the slides. You can also download the PowerPoint presentation simply by clicking on the Download Files button to the right side of the presentation. As a reminder, and as was noted just a minute ago, today's program is being recorded. It will be available on Foley's website by early next week, along with a copy of these slides in case you aren't able to grab them today. And then lastly, but not least, Foley will apply for HRCI and CLE credit after the web conference. If you didn't supply your CLE information upon registration for this conference, what you want to do is send an email to Jackie Polson at jpolson@foley.com. And as a final note, those seeking Kansas, New York, and New Jersey CLE credit are required to complete what is called the Attorney Affirmation Form. And later on during the conference today, I'll be giving out a 5-digit code that you'll need for that. You'll then need to email that code to Jackie Polson at jpolson@foley.com to receive a copy of the form. So I get to start off today. I'm talking about a few fun aspects of healthcare reform, and I'm going to start off with what is my favorite slide of my presentation, and which is why we're starting with it first. As you can see, it deals with the delay of the reporting requirements and the shared responsibility penalties. So unless you've been out in the dark literally for the past couple of years, you know that part of healthcare reform generally requires most employers to provide healthcare coverage to 95% or more of their full-time employees, and to provide coverage that is both affordable and provides minimum value. And as part of that, the government is also requiring employers to report this information back to specific agencies within the government. If an employer fails to provide the coverage or fails to provide coverage that is affordable or meets that minimum value standard, then it can be subject to certain penalties. I've heard these penalties referred to as the shared responsibility penalties. Sometimes they're called the pay or play penalties. Sometimes they're referred to as the $2,000 and the $3,000 penalties, and I've seen a few other monikers as well. I'm not going to go into any great detail about these reporting requirements or the penalties themselves, some of which we've covered in prior presentations, but also because of the fact that both of these have been delayed until 2015. And to make a long story short, what happened was that the government was getting a lot of pushback about these provisions and these reporting requirements from employers who said basically that they needed more time to comply. And so at the beginning of last month, the administration essentially acquiesced and said compliance wouldn't be needed until 2015. So that means there's no requirement to provide any coverage or to worry about whether any coverage that is being provided is affordable and meets that minimum value standard, at least not until 2015. What do we still have to worry about? The short answer is everything else. Essentially, nothing else was delayed, but we're still getting a lot of questions about some items and whether or not they were delayed. And in addition to that, there are several items that are coming up in the near future that you want to know about. And I'm going to cover these 5 items in the next few slides. So let's start out with the 90-day waiting period. For any plan years that are beginning on or after January 1st, 2014, your health plan cannot have a waiting period for participants to enter that is greater than 90 days. And just a note, I'm going to be referring to this January 1, 2014 period over and over again. This is a simple rule. Don't make it more complicated than it is. 90 days means just that. It means 90 days. We're not talking about 3 months here. We're not talking about 3 calendar months. It's 90 days. And I realize, and I'm sure the government realizes this as well, that there are many plans out there that approximate or come close to something that looks like this 90-day waiting period, but doesn't quite match up. And again, the rule is after January 1, 2014, you need to make sure that 90 does mean 90. The prohibition on pre-existing condition exclusions. This is really a rule that has been implemented in pieces, and I'm going to skip to that second bullet point. For some time now, there has been a prohibition on pre-existing condition exclusions for participants and beneficiaries who are age 19 and under. And starting for plan years beginning on or after January 1, 2014, there's that magic date again, you cannot have any more exclusions for any participants. Out-of-pocket maximums are what are sometimes referred to as cost-sharing limits. So again, there's my magic January 1, 2014 date. Any plan years beginning on or after that time cannot have an out-of-pocket maximum that is greater than $6,350 for single coverage or $12,700 for family coverage. Note that the limits here apply to these 4 items: deductibles, coinsurance, copays, or similar charges. But the limit does not apply to premiums, non-covered services, or non-network balance billing. It's our opinion as well that these limits are probably only applicable to essential health benefits. We don't have full and crystal clear guidance on that yet, but again, in our opinion, that's what the limits apply to, and unless we receive different guidance going forward, I think that's how it's going to be. Also, a special note, and one that's not noted on this slide, is that we believe these out-of-pocket maximums would apply to any and all options under your major medical plan. For instance, maybe your medical plan has a gold, a silver, and a bronze option. And right now, it's only the gold option that meets that out-of-pocket maximum. We believe that starting with that magic date and going forward, the other options also need to comply with those out-of-pocket maximums or those cost-sharing limits. So if you're like just about everybody else, it's very possible that your plan has both a major medical and a prescription drug component that are operated by different service providers. And back in February, the Department of Labor, or the DOL, came out with some helpful advice saying, look, we understand it may be difficult to coordinate the out-of-pocket maximums between two providers, so we're essentially going to give you a free pass for the first year. No coordination is required for that first year. Note that it's possible then, in fact, probably very likely, that because you have separate providers, you have separate pieces right there, as long as they each comply with those out-of-pocket maximums, it's, again, quite likely that that may lead to higher maximums, out-of-pocket maximums for participants for 1 year. And on a related note, you may have seen a lot of scuttlebutt or news articles talking about what I think is a bit of a misnomer, but it's saying there's been a 1-year delay in the out-of-pocket maximums. And what it's saying is this, is in that DOL guidance that I was just talking about, it says that if you have a non-medical portion in your health plan, and that non-medical portion has a separate provider, that the out-of-pocket maximum only applies if there is an out-of-pocket, if it does have some sort of out-of-pocket limit on it. And what I mean by that is if it has some cost-sharing limit, it has to comply with the numbers that I just noted on the prior slide. But it's also possible for it to not have any cost-sharing limit. And again, as long as we're talking about separate providers, this is going to be permissible, at least for that 1-year time period. So that's caused a lot of people to be up in arms, and I think somewhat understandably so, just because everyone on this call probably knows how expensive those prescription drugs can be at times. That being said, that's what the rule is right now, is that the non-medical portion, the prescription drug portion, does not have to have an out-of-pocket maximum for this coming year. The exchange, or what is now being referred to as the marketplace notices, and I'm going to spend a few slides about this. These are the notices that provide employees with information about their coverage options that they can obtain through the marketplace. I just want to talk real quick about the penalties and how that is still being determined for failing to provide the notice or possibly failing to provide an adequate notice. And the reason we don't know what the penalties will be as of right now is because the marketplace notice is a requirement that comes under the Fair Labor Standard Act, the FLSA, and the penalty provisions under that law don't quite work for this notice. So we expect additional guidance to be coming in the future about what possible penalties could be. Which employers must provide the notice? Here there's a very wide net that's being cast. And if you fall into any one of these 4 categories, this is a notice that you need to provide. If you have 1 or more employees and $500,000 or more in annual sales or receipts, you need to provide the notice. If you're a hospital or you're an institution that's primarily engaged in the care of the sick, the aged, the mentally ill, or the disabled who reside on the premises, you need to provide the notice. If you are a school for children who are mentally or physically disabled or gifted, or you're a preschool or an elementary or secondary school, or you're an institution of higher education, such as a college or a university, you need to provide the notice. And finally, you need to provide any federal, state, or local government agency also needs to provide the notice. So the corollary to that last question is, who has to receive the notice? Who do you have to give it to? You have to give it to each employee. It doesn't matter if the employee is part-time or full-time. It doesn't matter what their enrollment or eligibility status is. If you have an employee, you should be providing the notice to them. Note, however, you don't have to provide the notice to dependents or other non-employees, people such as retirees, or if you have an employee who terminates employment and then goes out and gets COBRA coverage. I just want to note that on the COBRA coverage, the COBRA notice form has been updated so that it will now talk about the marketplace. When do you have to provide the notice? It's coming up pretty quick, so this is a date to pay attention to. You've got to provide it no later than October 1 of this year or when someone is hired, and that means within 14 days of that person's start date. This is kind of my where's the beef slide part 1. What does that notice have to contain? And that's all I'm talking about on this slide. There are 3 items that the notice must contain. I'll talk in a couple of slides in just a minute why it might be a good idea for your notice to have more information on it. But the minimum requirements are fairly basic, fairly simple. You have to have marketplace basics on the notice. You have to talk about the existence of the marketplace, a description of the marketplace and its services, and then contact information for the marketplace. You also have to talk about the ability for an employee to be eligible for the premium tax credit, kind of the circumstances under which someone might qualify for that. And then finally, you need to talk about marketplace usage. You need to provide an explanation of the possible loss of an employer contribution someone might lose out on. Instead of seeking the coverage that is offered through the employer, they go out to the marketplace and seek other coverage. The DOL has been pretty helpful here in that it's provided 2 model notices, one for employers who are offering coverage and one for those who are not. If you look at these model notices, you will find that not only do they contain the mandatory information, not a big surprise, but there's also information on there that an employee would need to go out and seek coverage through the marketplace. And it would include items such as eligibility criteria for employees and dependents, whether the coverage the employer is offering meets the minimum value standard, and whether that coverage is intended to be affordable. And then it has some optional sections that deal with items that are specific to the employee, such as what are the required employee premiums. So here's the slide I alluded to earlier and why you might want to use the model notice or why you might want to provide more than the bare minimum of information that's required to be on the notice. And the first answer that I have is just a practical answer, and that is if you look at the marketplace application form, you will find that it is either a 5-page application form or a 13-page application form, depending on the person's situation and circumstances. In either event, no matter what form is being used, the person will need a boatload of information about the employer's plan. And so what is going to happen is if you don't provide that information in the notice that you give to your employees, it's likely, and it's probably highly likely if you have a big employee population, that the employees are going to be coming back to you and asking for that information. And so my advice is to cut all of that off at the head and to simply give the information that the employees are going to need and may be coming directly to you and asking for that. The DOL has also been helpful in that modification of the model notice is allowed, provided you have that information, that mandatory information on it. You can tweak it as you need to. And then I also think it's possible, if not highly likely, that vendors and third-party administrators that you may be contracting with may be considering using the model notice for all clients for consistency purposes, for ease of use. I think it's much more likely in the future that we will see notices that contain more than that bare minimum information. And lastly, I just want to deal with the one quick item that has come up for the summary of benefits and coverage. If you've ever been excited for more notices and more forms, I'm here to fill that need, or rather the government is here to fill that need, and I get to tell you about it. SBCs have been out for a while. Perhaps you've seen some or you've already been preparing some. The only item to add that I'm adding here is that there's new language that's being required for 2014. And it's that the form has to contain information about whether the plan provides coverage and whether that coverage meets the minimum value standard. The government came out with what I consider to be some very limited relief, saying, look, if it's going to be administratively burdensome for you to put that information on the SBC, you don't need to do it. But you've got to provide it in a cover letter. So either you put it on the form itself or you put it in the cover letter. I don't know if that's really relief at all, but that's where we are. And those are the great things about healthcare reform as of right now. And with that, I will turn it over to Sam.
Thanks, Isaac. Appreciate that, that description. It's very interesting. I'm going to talk about the Supreme Court's decision, or decisions, I should say, on same-sex marriage or the Federal Defense of Marriage Act. The decisions, before I describe them, I'm going to go through a little bit of a background. In the 90s, Congress became concerned that because of actions that were taking place in the states, although none of them had done it at the time, they were concerned that some states might start recognizing same-sex marriages. So in order to head that off at the pass, Congress passed the Federal Defense of Marriage Act, which did a couple of things, but in Section 3 it said that for federal law, the federal government would only recognize persons of the opposite sex as spouses or married. And that would be for things like the IRS or Social Security benefits, Internal Revenue Code, all those sorts of things. And then Section 2 of the Federal Defense of Marriage Act, or DOMA, the acronym it's commonly known by, said that states could decline to recognize the validity of same-sex marriages that were legally performed in other states. Now, this is different than the usual practice. If you've been in the business, you've worked with perhaps common law marriages coming from other states, and the general rule for most states has been that they would recognize marriages in other states even if that state wouldn't recognize it. So for example, marriages to second cousins or first cousins, I should say, and also for things such as I mentioned, common law marriages or underage marriages. Some states would recognize them, other states wouldn't. But with full faith and credit rules of federalism, the states would generally recognize other states' valid marriages. But Congress came along with Section 2 of DOMA and said that with respect to same-sex marriages, states could pass laws if they wanted to, declining to recognize otherwise valid same-sex marriages from other states. Again, this was all passed before any states recognized same-sex marriages. Well, those congressional legislators were prescient because, in fact, states did start recognizing same-sex marriages, and eventually a case worked its way to the Supreme Court where a same-sex couple, one of the spouses died, unfortunately, and left some money to her spouse. And it was a valid marriage under state law, but the federal government declined to recognize them as married for purposes of estate tax purposes. So this surviving spouse sued, and the Supreme Court granted certiorari and agreed to hear the case on Section 3, but the notion of Section 2 and whether one state could recognize and had to recognize another state's same-sex marriage was not part of the case, so the Supreme Court didn't consider that. The next case um, involved, let's see here. The next case involved California. And in California, there was a ruling in 2008 by the California Supreme Court that the California Constitution prohibited the then state law that only recognized marriage or would only grant marriage licenses and solemnize marriages between persons of the opposite sex. And so the California Supreme Court, citing to a 50-year-old U.S. Supreme Court decision, striking down as unconstitutional under the federal Constitution, state bans on interracial marriages, used a similar logic and said that California's refusal to recognize or grant same-sex marriages was similarly invalid under the California Constitution. That caused a backlash among voters who organized a petition under the state's proposition system, and they put on the ballot some months later an amendment to the state constitution defining marriage as only being between persons of the opposite sex, and that proposition passed by a majority vote in the November elections in 2008, effectively overruling the California Supreme Court by amending the Constitution that court had interpreted. Eventually, a suit was filed in United States District Court for the Northern District of California, arguing that Proposition 8 itself violated the United States Constitution. And the governor and the governor and the Attorney General refused to appeal when the district court held that it in fact did violate the U.S. Constitution. The Ninth Circuit eventually ruled on it after the California Supreme Court said that an appeal could be had by parties other than the governor and the Attorney General, as to say even if the state didn't want to appeal, that citizens who were interested could appeal. And so the Ninth Circuit ruled and upheld the decision of the district court. But an appeal was then made to the Supreme Court, and the Supreme Court again granted certiorari to look at this issue as well. So on these two cases, the Supreme Court came out to decide the question of same-sex marriage. In the first case, in U.S. versus Windsor, the Supreme Court ruled that Section 3 of DOMA, which denied federal recognition of otherwise valid same-sex marriages, was unconstitutional, and they attacked it primarily on a federalism argument. That is to say that it was improper for the federal government to get in an area that the states traditionally occupied, that is defining marriages, although there was some pretty strong language in the majority opinion about there not being any just basis from a due process kind of perspective for the DOMA rule as well. But the court, interestingly, did not rule on Section 2 of DOMA, and so it left in place the rule that states, if they wanted to, could have their own mini DOMA laws, and many of them do, that refuse to recognize same-sex marriages, and it didn't hold that states had to recognize same-sex marriages, and so states essentially are free not to solemnize same-sex marriages, and they're also free not to recognize same-sex marriages in other states. However, if there is a valid same-sex marriage, the federal government, based on this decision, is now required to recognize it. The second decision, the one involving Proposition 8 in California, so there it was a very narrow decision. The Supreme Court simply refused to decide the case because they said that since the state's officials refused to make the appeal, then it wasn't properly, there was no proper appeal. And they essentially overruled the Ninth Circuit for even listening to the case and effectively affirmed the district court decision holding that Proposition 8 violated the United States Constitution. And so the bottom line of all this was that same-sex marriages were once again allowed in California, and in fact they're being performed again. The governor, who was in favor of same-sex marriages, immediately began implementing solemnizing same-sex marriages again. So those are the two decisions. Now, let's look at the impact, and I'm going to break down the impact of the decisions. In California, the decision is fairly simple, that the state is now granting same-sex marriages. If you're in California, you've already had a period where same-sex marriages were solemnized, and now it's going to continue, and you'll have same-sex marriages. So the impact of the the Windsor decision, holding that Section 3 of DOMA was itself unconstitutional. So it has its biggest impact in the 13 states in the District of Columbia that currently recognize or solemnize same-sex marriages. And these are listed here as California, Connecticut, Delaware, Iowa, Maine, Maryland, Massachusetts, Minnesota, effective just this month, New Hampshire, New York, Rhode Island, effective again just this month, Vermont, State of Washington, and the District of Columbia. So in all these states, same-sex marriages are being performed and solemnized by the states. So employers in those states have a live issue in that they have a fairly good population of same-sex spouses to deal with in their employee benefit plans. Now, in the retirement plans in those states, I'll break it down into two categories. If you've already covered same-sex spouses, and I will say that in our experience in these states, many employers do recognize same-sex spouses. So if you're already covering same-sex spouses, then your plans on the retirement plan side will likely need to be revised to eliminate any provision that made a distinction between same and opposite-sex spouses. What do I mean by that? Well, there are a number of clauses in retirement plans that apply to spouses. But before the Supreme Court's decision, if your state recognized a same-sex spouse but the federal government didn't, you had to tailor your plan in kind of a tricky sort of way to deal with the dual set of laws. So for example, in quadros, if a qualified domestic relations order came in, generally you're allowed to make in-service distributions to the alternate payee, the ex-spouse, even though the participant is still working in the face of a quadro. But if you had a same-sex spouse that was recognized under state law but not under federal law, so then that you didn't have that permission under federal law to make the in-service distribution, so you had to have a special provision. In the case of required, and so now if you had jiggered your plan to deal with that, you need to fix it. With respect to required minimum distributions, there are special rules for spouse beneficiaries that allow the payout to take place over a longer period of time. And if you were in a state that had same-sex spouses and you recognized them as such in your plan, you still had to, in the required minimum distribution section, carve out a special rule for same-sex spouses, treating them as non-spouse beneficiaries for federal purposes. In other words, they didn't get as long to take their benefits. Well, now you're going to need to go back in and undo those provisions to treat the same-sex spouses as spouses. On direct rollovers, there is direct spouses. A spouse beneficiary can make a direct rollover into an IRA in his or her name, whereas a non-spouse beneficiary can only make a direct rollover into an inherited IRA. Again, if you lived in a state where you had same-sex spouses, but before the Supreme Court's decision, you had to parse that out and treat the same-sex spouse as a non-spouse beneficiary for this purpose. Now you're going to need to go in and rejigger your plan to make it clear that the same-sex spouse, just like an opposite-sex spouse, is entitled to a direct rollover into an IRA in his or her own name. If you, on the other hand, if you excluded same-sex spouses from your retirement plan by tying your plan's definition to DOMA, and you're in one of these states, you're going to likely need to amend your plan to conform your definition to the state's definition, because now under ERISA, your plan will be required to provide certain benefits and rights to spouses. Well, I should say it's always been required to provide certain benefits to spouses, or for many years anyway. And now with the Supreme Court decision, so these same-sex spouses are now treated the same as opposite-sex spouses for purposes of these ERISA requirements. And these are listed here if you have a joint and survivor annuity, or a pre-retirement survivor annuity, or a qualified optional survivor annuity. These requirements, which you had to offer to opposite-sex spouses, you now also have to offer to same-sex spouses that are recognized under your state's law. With respect to spousal death benefits, you're supposed to get spousal consent if you have a non-spouse beneficiary as a general rule in retirement plans. And there are rules for that. These now will apply to same-sex spouses. even if your plan previously didn't recognize them. So you'll need to make sure you amend your plan to deal with that. We talked about direct rollover rights. These now have to be extended to same-sex spouses, so you'll need to amend your plan. Require minimum distribution for spouses. Again, you're going to have the special rules in there for them, and quadros. So all of the same things we had talked about with respect to a plan that was already covering them is going to go into need to tweak it. If you're in a plan, if you have a plan that didn't cover them or expressly didn't, you're going to need to go in and undo that. If you have a church plan or a government plan so that you're not subject to ERISA and you live in one of these states, you have your business in one of these states, so then the ERISA requirements will not be applicable, but state law non-discrimination rules, which may discriminate such things as marital status discrimination, sexual orientation discrimination, these sorts of things may well require you to offer these benefits to same-sex spouses. And those rules, there wouldn't be any preemption argument under ERISA. And so you're likely going to find yourself needing, if you didn't already, to comply with these with the same-sex spouse in keeping with the new federal ruling by the Supreme Court. And each state, you'll have to look at your situation carefully with your legal counsel to decide how that's going to play out, but it's an issue you need to look at. With respect to health and welfare plans, again, if you're in one of the 13 states or the District of Columbia, if your plan, and a lot of our clients in these states have in fact been covering same-sex spouses under their health and welfare plans, then you're going to need to make some changes because of this decision. The first thing is that health care coverage, medical, dental, and vision, can now be provided tax-free to same-sex spouses, even if they're not otherwise tax dependents. Previously, even if you followed your state law definition, recognized same-sex spouses, you could give them generally a tax exclusion under state law, but you didn't get to give them a tax exclusion. You had to impute income to the employee for federal purposes. So now this is going to change. So the point here is that for many employers, this is going to be good news. You're going to end the dual tax reporting regimes for state and federal tax purposes in the case of same-sex spouses. Now, I will say that a lot of these states also had registered domestic partners or some sort of non-marriage civil union, and in those instances, unless the IRS comes out and equates them to marriage in light of the Supreme Court decision, which I don't know that they're going to do, we'll assume that they won't for now, then you may well still have dual regimes for the civil union people as opposed to the same-sex marriages. Now, with respect to, again, this is a plan that had covered same-sex spouses. You're now going to be able to allow the employee with the same-sex spouse to begin paying his or her employee share cost coverage premiums on a pre-tax basis, where before you had to make them pay it on an after-tax basis. You're also going to allow same-sex spouse benefits. You could pay for their benefits, their health care under flexible spending accounts, health reimbursements accounts, or health savings accounts. And so before, the only time you could do that is if the same-sex spouse was also a tax-dependent, independent of the spousal relationship. Now you don't have to have that, go through that tax dependency test. You just look at the spouse relationship. Same-sex spouses will now be entitled to full COBRA rights. Before, even though you may have covered them under your plan, the same-sex spouse was not treated as a spouse for federal law purposes, and therefore could only be covered as a dependent if the former employee elected COBRA coverage. But now the same-sex spouse will have independent COBRA rights. HIPAA special enrollment rights will also apply to same-sex spouses, and the FMLA, Family Medical Leave Act, leaves of absence rights will also apply to taking care of same-sex spouses. With respect to the states that don't recognize same-sex marriage, which is the majority of states, so if your state recognizes valid same-sex marriages performed in other states, as say you have people who immigrate to your state or went out of state to get married, then the coverage issues discussed above for states that do recognize such marriages would likely apply to your employee same-sex spouses from other states. If you've been covering it, you'll make the changes. If you haven't, you'll need to think about whether you need to. If your state does not recognize valid same-sex marriages from other states, then at least until further guidance is issued, your plan's likely to be construed to not treat same-sex spouses from other states as spouses because, again, as I mentioned, the Supreme Court left Section 2 of DOMA intact. Now, the guidance is still being issued in this area, and it's coming down inconsistently. The Department of Defense, within the last week, Chuck Hagel issued a rule that the Department of Defense benefits would look to the state of celebration to determine whether someone is married, and the Department of Labor has said that for FMLA leave of absence purposes, they'll look to the law of the state of residence. So again, you're going to need to parse this fairly carefully. Hopefully the feds will come out with some global guidance on this issue for the many people in states that don't currently recognize same-sex spouses, and we expect that further guidance will be issued later this year, especially from the IRS is probably the most important. When are the rulings effective? Well, potentially a Supreme Court decision, because they declared the law unconstitutional, could be retroactive back to 1996. And the Hollingsworth, the Prop 8 decision, could potentially be retroactive back to 2008 when Prop 8 was passed. But I wouldn't take any action on that. We expect the IRS and other agencies to issue guidance on this question and give some notion about how far back they think all this should go. We talked about civil unions. I already mentioned briefly that there are a number of states that have non-marriage civil unions. Absent contrary guidance, at this point, they would not be recognized as marriage for federal law purposes. But we'll be sure to be watching for the IRS guidance on the subject. What should employers be doing now? Well, the first thing and the most important is to watch for guidance from the IRS primarily and for other federal agencies, which hopefully will come out soon enough before the end of the year to take any action you need to take. Review your plan documents and procedures in the areas that we've mentioned here. And anywhere else you mentioned spouse to see whether something needs to be changed. Look at your leave of absence policies to see whether you need changes there. Very important thing, you need to review your payroll practices to ascertain where changes will be need to be made. And this, as I mentioned, a lot of employers had dual or even triple payroll systems to deal with the different tax regimes at state and federal level for same-sex spouses. So you're going to need to change this. IRS guidance will be coming. I suspect that it'll be for the whole year, this tax year. I doubt it'll go back any further than that, but we'll see. You have to watch that guidance. You should be gathering data on same-sex spouses if you don't already. If you have one cubby hole where you put domestic partners and same-sex spouses, you need to break it out and keep track of the same-sex spouses. And then the final thing is there's been some scuttlebutt out there about whether you should be looking at applying for a refund for past employer share FICA taxes. This would only be in states where recognized same-sex spouses and imputed income. I would say you look to see if it makes an economic sense, if there's enough people that it would be worth the bother to file such a claim, but there might be a basis for it, and so you should at least think about it. And with that, I'm going to turn it over to my partner, Mike Wooliver, who's going to talk about subrogation clauses.
And Mike, really quick, I'm just going to jump right in. At this time, I want to announce the 5-digit code for those seeking Kansas, New York, and New Jersey CLE credit. The code is 65SJF. Again, that code is for those who are seeking CLE credit in Kansas, New York, and New Jersey. One more time, the code is 65, S as in Sam, J as in Jack, and F as in Frank. Sorry, Mike, go ahead.
Thanks, Isaac. I'm going to talk about another Supreme Court decision, one that came out roughly the same time in April this year, dealing with a much more mundane but equally important issue, namely when a plan has a right to recovery from one of its participants under subrogation provision pursuant to Section 503 of ERISA. And the Supreme Court decision in McCutcheon is a very interesting case, in some ways very problematic from a lawyer's point of view because it didn't provide very clear guidance in some areas, but some important guidance in others. And it underscores the fact, two things. One, how careful drafting is the key to having an effective subrogation provision or any other provision where you're trying to create a right to recapture funds paid to a member, as well as the courts continuing to struggle with the whole concept of when equitable remedies are available to plans under Section 502 of ERISA. McCutcheon is not the first time the court has dealt with this issue. There's at least 4 other cases that I'm going to talk about briefly. Mertens versus Hewitt Associates, Great West Life, Sereboff and Cigna versus Amara, all of which you can see the court struggling with this concept of when can a plan recover, and in some cases when participants are protected by 502A3 claims. Another concept that I'll talk about and I want to mention briefly is the concept of complete preemption. The Supreme Court has consistently held that Congress intended Section 502 to provide a comprehensive and exclusive remedy for plans and for participants and other claims that involve ERISA plans, and that any state law claim that you could think up that would supplement or replace or enhance the remedies that you had under 502 would be basically preempted and not available. And this is very important in the context of Section 502A3, which basically authorizes suits by both plan participants and beneficiaries as well as fiduciaries on behalf of the plans to enjoin violations of ERISA and to obtain, and this is important language because we're going to talk about it quite a bit, other appropriate equitable relief to redress violations of ERISA or to enforce plan terms. Obviously, if you are seeking to get money back from a participant pursuant to a subrogation provision, you're seeking to enforce a plan term. The Mertens case is the first time that the court really addressed the issue of how broad are the remedies available under 502A3. It involved the Kaiser Steel pension plan. Kaiser had gone into bankruptcy. PBGC had taken over its pension plan. And as a result, participants in the plan only got their statutorily protected benefits under ERISA and lost the rest of their benefit accruals because there was not sufficient money in the plan. A suit was brought by some of the participants against Hewitt, who was the actuary for the plan, and the basic theory of the case was that Hewitt knew of certain business changes going on at Kaiser, that those changes should have caused Kaiser to change its actuarial assumptions and make significantly greater contributions to the plan, and that Hewitt basically let Kaiser get a pass in terms of determining how much to put into the plan. By the time the case got to the Supreme Court, the sole issue was whether or not the participants could actually recover damages in the form of lost benefits from Hewitt, considering that Hewitt was a non-fiduciary, even though Hewitt may have actually facilitated Kaiser's fiduciary breaches under ERISA. Basically, the court looked at the language, other appropriate equitable relief, said it doesn't say other relief, it says equitable relief. That has to have some meaning. And really looked then at 2 issues. One, Section 409 of ERISA makes a fiduciary liable to the plan for damages that the plan incurs as a result of a fiduciary breach, which would have been covered here, but the court said that Hewitt was not a fiduciary and can't be held liable under 409 even if it helped a fiduciary cause a loss to the plan. And more importantly, and what is cited all the time now, the court said that if a plan seeks relief under 502A3, its relief is limited only to the types of relief that were typically available in equity back when there were separate equity and law courts, and that you had to go back and look at lots of decisions from the 1890s and 1830s and 1910s to figure out whether or not someone had relief under ERISA. And that because the relief sought here was in the form of a monetary penalty, monetary damages, that was a legal claim, not an equitable claim, and therefore they had no claim against Hewitt. The next case that came along was Great West Life. That was a case that involved a subrogation provision, specifically. So it was a claim by the plan to enforce its subrogation right against a participant who had been in an automobile accident, claiming the right to reimbursement from the settlement that the participant received in his tort suit. The tort settlement itself had basically identified a dollar amount and then allocated it. A significant portion was allocated to a trust formed under California state law that was intended to cover future medical benefits by the participant who had been very seriously injured. Another portion was allocated to pay the legal fees of the participant's lawyers, and then a small residual amount was allocated to the subrogation claim. And Great West argued, obviously, that its subrogation claim should be first, not third, that it should be paid, and then the rest of the settlement allocated on some basis. And it sued in federal court to enjoin the settlement and to enforce the terms of the plan. Following on its decision to merchants that basically the plan could only recover on an equitable theory, not on a legal theory, the court contrasted two kinds of restitution. Again, looking back to old case law to make this distinction. One was a remedy and restitution at law, where you were seeking to impose a legal obligation on the defendant to pay you money, and restitution and equity, where you were seeking to impose a trust or equitable lien with respect to particular funds or a particular piece of property that the defendant possessed. In this case, the court said that what could only be what Great West was seeking was a remedy at law, because in effect the plan participant received nothing in the settlement. It went into a trust for his benefit, but he didn't receive that and didn't control it. Went to his lawyers directly under the settlement. He never went through his hands. And therefore there was nothing, no property in which they could actually impose a lien in the hands of the participant, so they must be seeking legal restitution, which they can't do under A3. Interestingly enough, the court actually addressed the issue of whether or not Great West might have a state law claim and declined to opine one way or the other. However, it's very clear, based on subsequent cases, that almost most courts will find that if the claim that the insurer or plan is attempting to make could have been brought under A3, complete preemption provides, and therefore, if you cannot make a valid ERISA claim on behalf of the plan will have no remedy because any parallel state remedy will be preempted. Sereboff is the first case where the plan actually won, which makes it an important case. It was also, like Great West, a subrogation case trying to recover against a tort recovery. The facts in Sereboff were clearer. There was a very clear, well-written subrogation provision that made it clear that the subrogation claim was against the first dollar. On its face, and in addition, the plan had sent a lien notice to the lawyer representing the participant, and ultimately got an agreement with the participant to segregate an amount equal to its claim into a separate account to be held pending resolution of its lawsuit. That made it very easy for the court to distinguish Great West, where nothing went to the participant, to here, where a specific fund of money went to the participant, was set into a segregated account, and easy, therefore, for them to say that there was an asset that could be subject to a lien. And the court then went on to distinguish an equitable lien sought as a matter of restitution, which the court should basically say, if I say, you have my car, give it back to me, and you have subsequently sold my car, then I have, because you don't have the car anymore, I can't trace the property to your hands, I lose that claim under an equitable restitution theory, versus an equitable lien theory, where there's an agreement that there'll be a lien on the property, which attaches to the property, in which case the property can be a future fund of money that's not even in existence when the lien is made, and therefore tracing doesn't apply. There is still, as I'll talk a little later, some courts have basically still say you have to have the specific funds traced to the participant, but most courts have not under the Sereboff decision. The next decision is a sort of a totally different decision, but talks about A3 in an important way and does have a direct effect, as you'll see on the McCutcheon decision. It was a case called Amara versus Cigna. Amara was like Merton's, and it's a participant claim as opposed to a plan claim under A3. And Amara involved participant claims related to Cigna's conversion to its defined benefit plan to a cash balance plan, and whether in making that conversion, Cigna had misled the participants as to the real effect of the new plan on their overall benefits. In an amazingly detailed, complicated lower court opinion, probably one of the best written lower court opinions I've ever read, the court found that Cigna had basically lied to the people, had consciously lied to the plan participants to try to hide the fact that older participants, because of the way that the two plans work together, would not likely accrue any additional pension benefits for years under the new program, even though they've been told that they would get an annual benefit accrual under the new program. The court found that was a violation of ERISA, and the court then ordered Cigna to administer the plan consistent with the various statements that had been made to the participants about their benefit accruals, and basically to ignore the plan document. In doing so, the court looked at the Merton's decision and said, well, I'm really ordering them to give more benefits to the participants. That's effectively a monetary relief that I'm giving them, and therefore I can't do that under a Merton's decision. So therefore, I'm going to order it under A1B of ERISA, 502A1B, which is basically a provision that allows participants to sue for benefits under the terms of the plan or a clarification of their rights under the plan. And the court clearly was saying that the statements that were given effectively amended the plan. The Supreme Court turned the whole case around the other way. It initially held that 502A1B only allows the court to order benefits be paid in accordance with the terms of the plan, and it can't change the plan or amend the plan. And importantly, equally importantly, that the summary plan description or any other communication that's made to participants outside the plan are merely descriptive and are not the terms of the plan and cannot be enforced under A1B. Therefore, saying the lower court had basically ordered relief under a provision where it wasn't available. However, the court then said, if you apply Merton says any equitable relief can be provided, and equitable relief can include monetary relief where it's an appropriate part of the equitable remedy, which could well be the case in Amara. It then set the case back to the district court to apply its findings under the A3, and ultimately the court ended up giving the same relief to the participants that he ordered initially, which is basically additional benefits under the plan. McCutcheon is like Great West and Sereboff, very similar facts. Automobile accident, the plan pays medical benefits to the participant recovers in a tort action. Unfortunately, a very bad fact in McCutcheon was that the driver who caused all of the havoc was uninsured and didn't have any assets, and therefore what McCutcheon recovered was less than his medical bills after paying his lawyers. McCutcheon argued that, again, he should get his damages first. McCutcheon was very seriously injured, and there was testimony that he could have recovered millions of dollars of tort damages, and he recovered very little. And second of all, that even if the subrogation provision applied under the well-established common fund doctrine, the recovery under the subrogation provision has to be reduced by legal fees. And finally, that under Sereboff, in McCutcheon, the lawyers had actually taken a small amount of money, which they computed to be the amount of the subrogation claim less an appropriate allocation of legal fees, and set that aside. And McCutcheon argued that the only assets they could reach under Sereboff was the segregated assets. The district court granted summary judgment to the plan to U.S. Airways, basically said the provisions were clear and unambiguous. There was no tracing required under Sereboff because there was an equitable lien, and they didn't understand what McCutcheon's beef was. The Third Circuit reversed and remanded under a very unique theory. It basically read the Amara decision as saying that the court could rewrite plans not under A1B, but under an equitable theory under A3. That the A3, if you read it, says that you're entitled to other appropriate equitable relief, and that it would not be appropriate to give relief where the plan was unjustly enriched by not sharing in the legal costs that were incurred by the participant to make the recovery. The Third Circuit specifically refused to recognize decisions in most other circuits that basically held that even when the claims were equitable, the equitable claim could not change the clear plan terms. Again, in the court's view, Amara showed that plan terms were subject to modification based on equitable principles. The Supreme Court really addressed two arguments. One, whether or not the plan was clearly entitled to first dollar recovery, and second of all, whether or not that first dollar recovery was subject to offset by some portion of the legal fees. The court held that, contrary to what the Third Circuit said, even under A3, if you have a clear statement of rights, that clear statement of rights has to be followed, and you cannot reform a plan based on equitable principles. And then it also held that the common fund rule wasn't applicable unless the plan clearly allowed the common fund rule to be applied. So again, if you draft this properly, you can always have a first dollar recovery provision. But then it did something that sort of undercut that argument to some degree. It basically said that the common fund principle was so well established in the law that in drafting its subrogation provision, U.S. Airways should have addressed it. And by making its agreement silent, it created ambiguity, and whether when it used the term recovery, it meant net or gross recovery. And therefore, it was, again, because of the wide acceptance of the common fund provision, it was appropriate for the court to interpret the provision to say it meant net recovery, net of legal fees, and that's exactly what it ordered. The ruling is very problematic, one, because most lawyers wouldn't have thought of that, because you've got to basically anticipate everything in drafting rather than saying we get first dollar recovery, and also because in the extensive litigation and pleading of the issues leading up to the decision, there had never been any issue about the ambiguity of what was at issue. There was never anybody arguing that it was ambiguity. There was an ambiguity under the existing language as to whether or not it was net or gross recovery. But the court decided to make that an issue. Some takeaways from this. Both Amara and McCutcheon make it clear that the summary plan description or any other communications with participants are not part of the plan. There have been a number of lower court cases agreeing since then, saying that you cannot enforce a subrogation provision that's only in your SPD. So if you've got a subrogation provision, make sure it's in the plan document. Second, obviously, it's important that you clearly define the scope of your subrogation right. If it's a first dollar right reduced by any other cost or any other allocations to the participant, make sure you say that. Third, make sure your language is clearly drafted so that you can meet the requirements of Mertens and Sereboff, that there be a clearly designated, defined fund of money that belongs to you and that you have a claim against or a lien against. There was a recent district court case, just came out about 2 weeks ago, interpreting a defined benefit plan provision that said that in the event of an overpayment, the plan had a right to offset against future benefit payments. The court specifically didn't say anything about what happens if there was a lump sum payment. In this case, the participant had taken a lump sum, actually was paid twice, and the court said, your document doesn't say anything about having a lien against the money you pay in error. It only says that if you pay in error, you have a lien against money you haven't paid, and refused to give the plan any recovery. And finally, it's always a good idea to try to get, if there's a dispute about your claim, to try to get something segregated so that the tracing issue that we think has been resolved by Sereboff and would seem to be even more resolved by McCutcheon, at least the Ninth Circuit is still arguing that tracing is required even if there is a lien by agreement. Sorry, I'm trying to move. There we go. The final thought is the Supreme Court is clearly still very divided in the area of 503 claims, 502A3 claims, just as it is in many areas. There's one element of the court that seeks to apply the provision very literally and say that legal remedies are not available and equitable remedies will be narrowly interpreted. There's another element of the court who says that you've got to read equitable relief consistent with the policy behind the enactment of ERISA, namely to protect plans and plan beneficiaries, and that there's a general principle equity that equity leaves no injured party without a remedy, and the court should always fight not to leave a plan without a remedy or a participant. Clear drafting can only do so much in that context when you have such a divided fundamental principle and disagreement between the court, but clear drafting obviously limits the court from going too far off a road and needs to be gone forward. And I'm moving on. Isaac, you have some final thoughts?
Yes, well, thanks, Mike, and thanks to Sam as well. As you probably already noticed, everyone, it looks like we've run out of time. We do know there are a few questions that have been submitted. We'll follow up broadcast coming up in November. We hope you can join us for that. I just want to thank everyone for joining us today, for taking time out of your schedule to stay on top of these relevant topics. As I mentioned at the beginning, a copy of this presentation and the materials, the audio broadcast, should be available on our website early next week. Right here is a link to the survey that we ask for, and your feedback is very much appreciated, not only on this presentation, but for future presentations as well. Thank you again, everyone.
That will conclude today's conference. Thank you all once again for your participation today.